Good morning, everybody.
Good morning, David. Nice to see you. Yeah, we can see you, we can hear you. I'm gonna make a short introduction now in Ukrainian and then give a floor to you. Шановні колеги, доброго ранку. Ми раді всіх вітати сьогодні.
Dear colleagues, good morning. We're happy to welcome you in Ukrainian Crisis Media Center. Today on our agenda we have a very interesting discussion about Czech experience in judicial reform. We have a very interesting guest from Czech Republic. Unfortunately, he appeared unable to arrive, but nevertheless we are happy to have him for our discussion. One of the key elements in judicial reform is the law on the High Council of Judges, and today we will discuss the role which the High Council of Judges has to play in building up a fair judiciary system. I think that Ukraine is not only country which has issues with the judiciary reform, and there are some countries in the Central and Europe which face similar challenges in this area, and that's why experience of our Czech colleagues is of primarily importance for us. Professor David Kosar is Professor on Constitutional Law and Political Sciences from Masaryk University, Czech Republic. I would like now to present other participants of our discussion. We have Mr. Andriy Boyko in this room, member of the High Council of Justice. Then we have Ms. Victoria Ptashnyk, Member of Parliament and an expert from the Reanimation package of reform, Roman Masaryk.
If I may, we are now, as you may know, in the middle of transition, in the middle of judicial reform. This June, we amended the constitution, and it provides for establishment of the High Council of Justice, of the new High Council of Justice, which is a judicial council. And we hope that this new formation, where we have a majority of judges elected by judges in this council, will give more independence to the judiciary, but at the same time we fear that such composition may also lead to the judiciary not being able to clean itself, not being able to bring judges to justice, to the disciplinary proceedings, to make them more effective, and moreover it may block or stop the renewal of the judiciary, which is very important to us at this stage of the judicial reform, and also it may interfere in the process of holding judges accountable. So my questions would be to you, what is the Czech experience, and what is the experience? We know you're an expert on judicial councils and judicial reform and judicial composition. What is the experience of Czech Republic and other countries? Why are they different? And how can we remedy, if we already adopted this standard, what are the risks, and how in fact can we remedy these risks with other means, such as, for example, the broader participation of the civil society in the process, because we have this civic body, the Public Council for Integrity, that will help the judicial councils make its work. Whether this should work, or what other suggestions may you give us, also in the light of the European standards and the Venice Commission recommendations? Thank you, and the floor is yours.
Okay. Thank you very much, Mykhailo. First of all, honorable member of the Parliament, honorable members of the High Council of Justice and the Ministry of Justice, dear colleagues, dear ladies and gentlemen, it's an honor for me to address you and discuss with you the issues of judicial councils and judicial self-government in general. And I'm grateful for this opportunity let me allow you at the very beginning to stress how much I am impressed by the depth and breadth of your knowledge and the way you approach judicial reforms most recently. So please take my contribution as a sort of suggestion and something like a food for thought that might be or might not be well transplanted into the Ukrainian context, which you of course know much better than me. I will start with the question Mikhail posed. Later on, I will briefly move to three other issues: the role of the Venice Commission and potential judicial solidarity in disciplining judges, and what is, in my opinion, a critical issue, that is the attempt to change the mindset of judges. So, getting back to the first question, basically how to deal with a strong judicial council, which is a majority of judges on it. Basically, from other countries with strong judicial councils, there are several lessons learned. First of all, the role of other actors is extremely important. By other actors, I mean, in particular, court presidents, senior judges, and judicial associations, because since you have a majority of judges on the Judicial Council, then of course you have to look far more carefully what's going on within the judiciary. And even if there is an incompatibility rule that, for instance, court presidents cannot sit on the Judicial Council, which from what I heard is the case in Ukraine as well, there is always a danger, for instance, that court presidents will try to push for their own candidates who are loyal to their cause. So, just
also, David, I'm terribly sorry to interrupt. If you could please speak a little bit slower, because we have simultaneous translation also going on. Sorry, thank you.
Great. So we have to look at the role of other actors. That is extremely important, and I mentioned court presidents in particular. So even if they cannot sit on the Judicial Council by themselves, they can actually make sure that their candidates who are loyal to their cause might be elected. The second important thing is that the role of legal and political culture is very important, and it is something that is extremely difficult to change within few months or even years. We also have to understand that there is no one-size-fits-all solution that works just for every single country. So feel free to take into account your specific historical, legal, and political developments in Ukraine. And it is also quite important to stress, and I guess you know it, that the judicial councils can be misused, it can be abused, and basically every type of judicial council can be misused and abused. What can be actually done to limit the potential problems with the strong judicial councils with majority of judges? I think that some of those issues have already been addressed in Ukraine. For instance, the incompatibility of the function of a court president with the membership in the Judicial Council. That is very critical, and it proved to be an extremely difficult problem to undo in Slovakia, in Poland, and in many other countries. The thing that is still in the constitution, and I'm pretty sure that you cannot change it immediately, is that the president of the Supreme Court is an ex officio chairman of the Judicial Council. That is something which caused significant problems in other countries as well, in particular in Slovakia. So this is perhaps some food for thought for the future. But there are other issues that can be addressed without changing the constitution, I believe. First of all, it's critical to define electoral districts for judicial members smartly. So, for instance, in Slovakia, it was very problematic if there was just one voting district, and therefore there was no regional representation, and it was easy to rig the elections of judicial members and to get the candidates just of one, let's say, faction within the judiciary, which was unified and was able to get the highest number of votes on the national level. So it's important to define electoral districts for electing judicial members. It's also critical to ensure a diverse body of judges, so judges of different levels of judicial hierarchy and different views should be elected to the Judicial Council. There are certain institutional rules that can be used for that. We can discuss it later. Regarding the potential problem with the majority of judges, if you want to solve that issue and if you feel that there is too much judicial solidarity, there are also other options. For instance, when the Judicial Council is supposed to decide on a certain issue, be it a disciplinary measure or something else, it can form smaller chambers. This is something that the Venice Commission suggested regarding the role of public prosecutors in Ukraine, because if I'm not mistaken, there are only 2 of them, and the Judicial Council is supposed to decide about them. So the Venice Commission, in one of its opinions, suggested that there might be a smaller panel where public prosecutors could have a more significant percentage of the members that would decide on the issues of public prosecutors. So that's the way around the majority of judges, if that is perceived or will be perceived as a problem. So basically you can create a body within the Judicial Council that has, for instance, 50% of judges and 50% of non-judges, or the composition might be different. Regarding the issue of contribution of the public and the Public Integrity Council, I believe that what is critical and proved to be a problem in many countries with judicial councils is that the judicial councils and their functioning is not transparent enough. So if you want to have some meaningful contribution from the wider public, either the general public or other legal professions or researchers and media, you need to make your judicial council transparent. Therefore, what the Americans say, the sunshine is the best disinfectant. You have to have judicial council proceedings recorded. You have to stress that the agenda of judicial council must be announced way a long time in advance so everybody can prepare. There should be written minutes of the meetings published pretty quickly after the meeting. That's the procedural issues. The substantive issues, of course, it requires open calls for any position, be it the original appointment, promotion, and perhaps a temporary promotion or the so-called stagiaires at higher courts. There should be some preventive measures, and I think Ukraine has already gone very far in that in a positive way. Financial and personal declarations, because that's something that is very, very important. Another set of issues, of course, is to establish an effective complaint mechanism and somehow define the mechanism how to protect the whistleblowers from within and outside the judiciary, who would actually signal the potential problems. So that's for the strong for the strong judicial council. There are 3 more issues I would like to address because I was asked to. There is a potential danger that the judicial council might be unwilling to discipline judges appropriately and to hold them to account. It's of course a matter of empirical investigation, and we will see in future how the new judicial council in the new composition will act in this way, and we'll see how many motions there are and how they address them. I would just like to stress that in many countries, disciplinary procedure with judges is considered a sort of quasi-criminal trial with significant consequences for a judge concern. So that's something you should keep in mind if you are thinking about extending complainants' rights and so forth, because even though the Strasbourg Court never said that that disciplining of judges falls within the criminal head of Article 6, the right to fair trial, and so far it has always fell within the ambit of the civil limb of Article 6. It's perceived as a sort of quasi-criminal trial. So basically, if this judicial solidarity pops up as a potential problem, there are again certain solutions, or there is perhaps a set of solutions that has worked in some other countries. For instance, one of them is to increase the number of actors who can initiate disciplinary motion against judges. Of course, you cannot go extremely wide on this issue, but perhaps an ombudsman in some countries, it is a special organ outside the judiciary, perhaps besides court presidents, besides Judicial Council, besides other actors who can initiate the disciplinary motion. So ombudsman or a special organ. So it worked, for instance, in Slovakia, which has also suffered from significant troubles regarding disciplining of judges under the strong Judicial Council. The second thing, which might be perhaps strange for the civil law country, but it worked as well, is to allow separate opinions at disciplinary panels. Therefore, if the panel is not unanimous, then the possibility of those who dissent, who disagree with the result, to append a separate, dissenting opinion is very important, because it gives you additional arguments, and it also limits the majority in its reasoning, because a dissenting judge may expose the problems with the majority opinion. Of course, it's important as well to think of other issues. In the Czech Republic, we have a disciplinary panel which is composed of 3 judges and 3 non-judges. And these 3 non-judges, members of the bar, members of the prosecutors, and members of the law faculties, this extremely increased public confidence in disciplining of judges, because it's not perceived like judges judging other judges, but it is perceived as a body that is composed of expertise from within the judiciary and external checks who decide on disciplinary misconduct. It's also good to have judges from diverse backgrounds, from different types of courts, different levels of judicial hierarchies, and sometimes to have also younger judges on disciplinary panels, because they perceive some issues differently. And again, and I will repeat myself here, the sunshine is the best disinfectant. So what has worked really well in many countries was to introduce public hearings, require the disciplining panels of the Judicial Council to publish decisions immediately, to give proper procedural rights to judge concerns, and also to issue annual reports. Basically, annual reports of disciplinary panels, how many motions they received, how many motions they decided, what was the result, and so forth. Now, a brief word on the Venice Commission. Follow or not to follow. I believe that the Venice Commission is doing a great job, but sometimes goes too far. And I believe that sometimes it does not understand the problems of post-communist countries completely. Therefore, it is viewing the post-communist judiciaries basically with Western eyes. And we have different problems, which perhaps requires us to come up with different solutions. So I think it's extremely important to address the opinions of Venice Commissions if there is no good reason to go to a different direction to follow them. But sometimes, basically, I would advise you not to back up that easily. So it's important to show that there are other means to achieve the same result. The other means that the Venice Commission so far basically requires. And it is clear that international bodies should define primarily obligations of results, not the means how to achieve those results. And I believe it would be helpful if you want to go for a different solution, to join forces with other countries that might support them. So, for instance, in Germany, Austria, and the Czech Republic, there is a significantly different model of court administration, and it works rather well, especially in Germany and in Austria. So it's not necessary to follow just the path that is required by the Venice Commission, but never try to trick or challenge the Venice Commission openly. It's always important to build alliances, to explain that there are other options, and to basically stress that the national specifics must be taken into account. And finally, within the last minute or two, allow me to address the last issue, that is changing the mindset of judges. Because I believe that mental independence is critical. Sometimes it might be even more important than institutional rules. It's of course extremely painful and lengthy process, but there are some issues that can be addressed. First of all, it's good judicial education. It should be skills-based. It should be focused on legal ethics, and must be open-minded and not hierarchical. Basically, having lectures from different levels of the judiciary, roundtable sessions to discuss problematic issues regarding interpretation of certain statutes, not just having lectures by judges of a Supreme Court. Perhaps invite some foreign experts, but do not overdo it, because foreign experts usually do not have the same amount of knowledge of your own system. So having a well-functioning judicial economy is extremely important and may do wonders. And the second is to establish an ethical council, because if you want the judges to change their behavior, you also have to tell them what is appropriate and what is not appropriate. And the disciplinary panels are not the only and perhaps not the best option to define the rules. So basically, it helped in many countries where there was a hotline for judges where they could discuss ethical issues that happened to them, and basically ask for an advice. Can I attend this meeting? Can I give a lecture to a private law firm? What happens if my wife runs to the parliament? How should I behave? And so forth. So that should be addressed prior to potential disciplinary motions. And it's good to create sort of case-based guide of judicial conduct, not the abstract ethical codex, but a guide of judicial conduct which would be based on cases, on real scenarios that happen to judges in your countries. And finally, in some countries, it was helpful to introduce compulsory education of judges, but the compulsory education that is not limited to judicial academy. Basically, that judges must attend certain amount of courses per year or per, let's say, 2 years, but they can do it at the law school, at different facilities, at European institutes, and also within the judicial academy. So you can have a broader network of potential educational institute. And I think my time is off. So at this moment, I would stop. Thank you very much for your attention, and I'm looking forward to your questions, comments, and suggestions. Thank you so much.
Thank you very much, David, for this very interesting and substantial introduction and for sharing your thoughts. Now, as I hear them, I wish we could done this before we amended the constitution, because many things are already there, and we kind of now have to stick to that at least for 1 year for the time being. But at the same time, there are many things that I see may be amended in the law and taken into account in the process. Does anybody have questions? Колеги, якщо є запитання до пана Давіда, я можете ставити українською, якщо незручно англійською, я буду перекладати.
Dear friends, you may ask questions in Ukrainian, I will translate them. Yeah.
Consultant, and I have only one question. In Ukraine, we have approximately 9,000 of judges. How many percent of these people we must change to break the old system?
Thank you very much. David, what's your take on that? What's the amount?
Well, I can tell from my table that very much depends on what percentage of judges are corrupt or perhaps commit some criminal offenses. I mean, this is extremely difficult to judge and to assess without knowing individual factual situation in individual cases. Let me tell you that, for instance, in the Czech Republic, after the fall of the communist regime, there was, let's say, 30% of judges replacement. So basically, 2/3 of judges remained on the bench, and 1/3 left. But I'm not saying that all of those left because they were deemed problematic. Some of the best legal minds left the judiciary because the salaries were rather low, and they wanted to earn more money in practice. And it is always easier to complement the purges within the judiciary with very, let's say, strict conditions for new judges who enter the judiciary. So. It is very difficult to judge it from here, from the table, how to address this issue. And moreover, it's sort of different if you address the, let's say, collusion and collaboration with the previous regime, which was the case in the Czech Republic after the fall of the communist regime, and another issue, how to address corruption, which might be more widespread, less along the ideological lines, and so forth. So you need, I guess, a good mix of basically sticks and sugars how to address this issue, and a complete purge of the judiciary. I believe that's almost impossible. The only country which has done that was East Germany, but that's because it was unified with West Germany, and therefore basically the West German lawyers imposed their own rules. All judges in East Germany had to reapply for their jobs. The numbers differed from one state to another. In general, it was somewhere like 50% of those previous judges were able to be reappointed, but in some regions like Berlin, you know, the infamous Berlin Wall shooting and so forth, more than 90% of judges were replaced in this area. So it really very much depends on individual circumstances, and I would be very cautious to shoot a number from my table and tell you what's the right solution here.
Thank you very much, David. We have only time for one brief question now. Якщо є ще питання, тільки одне коротке запитання, колеги. Якщо запитань нема, то тоді ми будемо дякувати.
Since there are no questions, David, thank you.
Just want to leave, we would love to do that as long as possible, but we want to leave a little time also for the discussion with our panelists. Thank you very much for contributing, and we really hope, and for your expert opinions, and really hope that you will be able to come in person next time, and we expect you here and look forward to fruitful cooperation with you on judicial reform matters. Thank you very much.
Okay, thank you very much. It was my pleasure to be able to discuss these issues with you. Thank you.
Thank you. Тепер, шановні колеги, ми від сесії.
Dear colleagues, now we will discuss urgent issues that we heard from David and other issues concerning Judicial Council. Because today we are speaking about the Council of Justice and whether it is possible to renew the sphere. And a lot has been said, and we have similar opinion on the Judicial Councils, and we have draft proposal. You can take it into account, but we will publish it, we hope, today. And also infographics will be also updated, but it shows our concerns on the transparency, also limited access of public, and if public will participate, it will help to change situation in the councils and improve the situation. Also, the renewal of council, and also the issues as to efficiency of disciplinary procedures and disciplinary actions. And from David we heard that sunlight is the best disinfector and the best prevention from corruption. And we have many questions relating to this law, and we wanted to be discussed according to the full parliamentary procedures. And in the 30th previous months, the changes to the constitution were entered into force, and we should adopt this law in order to start the work of the council. That's why I would like to ask Ms. Ptashnyk about the prospects of adoption of this law. So can it be adopted in the second reading, or what are the opportunities and what is your opinion? Maybe you have some comments on our position. Maybe you had the opportunity to study the materials we presented. Good afternoon, dear colleagues. Firstly, I would like to say that I should leave early because we will have session soon, and I identified the main problems or risks that can appear in justice reform in its development. I've thought about the law on High Council of Justice and its prospects in the Parliament when it will be considered, and we take into account that on the 30th of September, we provided responsibilities of hiring and firing of judges and bringing them to responsibility to the council, and this body will be responsible for many activities, and it will be responsible for the renewal of this sphere and the implementation of reform. And also in the Parliament, those procedures that were ongoing last week, for me, they clearly shown that separate politicians want to preserve their political influence on judges. And there was an issue discussed in the parliament on firing the judges, and these judges, they made violations, and I was surprised that people didn't want to vote against them. If these judges, they made violations, that's why they should have been dismissed. And 5 judges from Appeal Court of Kiev and some politicians made everything possible in order to stop this process. So they presented different arguments, starting from the fact that their violations are not proper ground for dismissal. But the only reason for dismissal is that they do not adhere to their oath. So some people try to influence the situation, and we should remove this political influence because a lot depends on this. Institutionally, at the level of constitutional changes that were put into force, we were able to remove this political influence. We deprived Supreme Council of this influence, and we made the High Council of Justice responsible. It should create balance. We understand that judges will be selected by judges, and the majority of them will be judges, and experts say that this part is not reformed. They will elect themselves. So the members of the Council of Justice, but at the same time I believe that here there should be balance from one side between people who understand and can assess whether some violations were made by the judge, and they should know procedural rights and procedures, and also people who represent this profession, but they are not representatives of the system. And Constitutional Commission worked on these changes, and the procedure was really long and hard, and there were a lot of discussions, and sometimes judges tried to block separate issues. And it started April last year, and the balance was found when the majority of judges will be elected by judges, and they based this on the recommendations of Venice Commission that it provided long before. And I take into account that as of today, our Council of Judges should be reorganized, and we need a proper law. And without adoption of law, the activity of the Council can be blocked. That's why, as of today, it is clear that the committee should introduce to the agenda the draft law of this law that was developed by the Council on judicial system, and to discuss this in the on the committee, and to introduce it to plenary session. And we don't know the reason, but it was not put in the agenda this week, and this discussion should take place soon, because this process can be delayed. And then it can, in any case, this discussion is necessary. And I believe that political forces won't block the adoption of this law from one side, and from the other, I want to say that there is an alternative draft law, and that was presented by opposition bloc, former Party of Regions, and from the side of opposite bloc, they didn't vote for the dismissal of judges. They want to preserve their judges and to prevent this reform. And that's why the discussion of law is important. This law was developed before it was registered in the parliament with some changes, but it was developed by the Council on Reform, and there were representatives of different forces. And being the member of this council, what I see as a risk is that judges themselves can block this reform. And this address that we have from the plenary session and some complaints on constitutional things are heard, and they don't want, the judges do not want to undergo reassessment, and they are against this, and they didn't like that we proposed to introduce, and we introduced the grounds for dismissal of judges if they cannot explain the origin of where their assets, and judges were absolutely against this because they said that there should be a common approach to all civil servants and the deputies, and no one is against this, and I believe that the approach should be similar to everyone, but it doesn't mean that we will wait until we do it to everyone else and the judges will be the last ones. And when before the changes were introduced to the constitution and the law on fair justice was adopted, so there was a possibility to start these procedures of renewal through reassessment procedure. And I remember the plenary session of Supreme Council wanted to apply to Constitutional Court to establish that these provisions do not correspond to existing constitution. So all those actions, they show that judges will evidently block this reform because they do not want to undergo contest, and this is about especially the judges of High Court, and the specialized court judges should be in the contest with the judges from the regions, from different courts. And here it is very important for the public. We should address that people should apply to these contests in order to compete in this contest to become the judges of the Supreme Court. And we should renew this court and to fill it with professionals who will be able to explain their assets, the origin of their assets, and all reform depends on this. And as to the High Council of Justice, we should pay more attention to it, and we should start the discussion in the parliament and outside the parliament. There were discussions, but this discussion wasn't started in the parliament. That's why, as a society, you should address and pressure the committee that they should put this draft law on the agenda and to discuss these issues in professional environment. So we should end our discussion, but I would like to express hopes that Euro-optimists will support reanimation of package of reforms proposal as to involvement of society in this process, and that this discussion should be also carried out into professional circles in order to reform the system, because this body is conservative. And I would like to ask other participant of the panel, Andriy Boyko, who is the member of High Council of Justice, and he is not the judge. So this gives the opportunity and characterizes him as a progressive member of this body. So how do you feel as a member of this council, and also what will be the changes, and also if you know our recommendations, do you agree or do you disagree on them? So please be brief. Okay, so you ask so many questions, it's difficult to be brief. I would agree with everything that was said by my colleague, Ms. Ptashnyk, that there is a pressing need to adopt the law on High Council of Justice, that this council won't be blocked. We clearly understand that not only the issue of hiring and dismissal is important, disciplinary responsibility is also an urgent issue to be considered, because it creates a lot of difficulties in the process of reforming justice. And I would like to stress that the draft law on High Council of Justice underwent preliminary hearing, and before this there were expert community involved in discussion, and the majority of proposals that came out of expert community were taken into account. And these were really useful proposals that improved the quality of the project of the draft law on High Council of Justice. And there are separate issues that are of concern, but we should understand that the development of draft law on High Council of Justice is the way to balance the various interests of the judges, interests of society, and the positions that were expressed by expert communities, their opinions, and also to reach the highest goal, that is, before adoption of the law, the High Council of Justice is the creation of the body that would be the key in the system of judiciary, and the activity of which would be directed to create independence in the area. And we see that 2 years ago the society questioned the independence of judiciary and courts in Ukraine. And another important aspect that we should take into account, that should find mechanisms to resolve this issue, is that to establish responsibility and accountability of judges and judiciary before society. And this is the matter of concern for the experts and for NGOs and High Council of Justice, whether it will be the body that will create opportunity to create transparency and accountability of the judiciary. I believe that the draft law on High Council of Justice is of quality, and maybe accept separate provisions that were expressed by our Czech counterpart, and I would like to speak more about these provisions, but I do not have such an opportunity today. But as to the forming of this body, the recommendations of many European bodies and the experience of countries of Central Europe shows that it would be really great if in this body, in this council, there would be the representatives of all instances, first appeal and cassation instances. And in the draft law this mechanism is not envisaged, but there is such a practice in Czech Republic, in Poland, in other countries, and in Poland, and the election of these judges is done separately. First instance elect their representatives, appeal court representatives elect their own, and cassation also select their own, and this prevents the influence in the process of forming this body. So this is the principle of quotas, and it is envisaged. So from separate regions, from different instances, judges are presented, and this improves the quality, and the assembly of judges, the meeting of judges will maybe take this into account. Other concern that is raised by expert community is to some peculiarities of disciplinary procedure. According to the draft law, the disciplinary proceedings, they are transferred to the High Council of Justice. This is a preliminary consideration. There will be disciplinary chambers and also review of these decisions that will be in the plenary session of the High Council of Justice. And there were some concerns that preliminary review and further review is done in the same body, but there are some preventive measures in the draft law. The most important thing is that the member of the council who is involved in this, he does not take part in the taking this final decision, and he cannot form his position while influencing his colleagues and convincing them that this decision is important to make. On the other side, in the process of review by the plenary session, those who considered this case preliminary, they won't be involved in the decision of the chamber. So some concerns were raised here as to limited capabilities on complaints, on possibilities of representatives of society, but I won't use such term as to influence the activity of the council. Maybe a positive influence can be, we can say. If we are speaking judges, judging judges, maybe this is quasi-judicial procedures. This should be done following the principle of fair justice, and in any case, the influence on this body is not allowed. Moreover, we should clearly understand that civil society should represent society, but I cannot say that they can be the members of these decisions, because they become engaged in the process of review. There are civilized ways how to solve these issues, as my colleagues say, and they create ombudsman. And in many countries this institute exists, and judiciary ombudsmen are provided from executive and legislative power, because we should understand that judiciary power should be responsible not only before society, but also before other branches of power. And in this case, civil society can complain and on the decisions of disciplinary bodies. So this is a civilized way. When at professional level, they defend the interests of society. As to quality review of disciplinary cases, and we will come to this in time. So for me, the most important thing is transparency in the activity of the council, the openness of the body, and concerning the openness of the meetings of chambers, disciplinary chambers. The law envisages the formula that is in the European states implemented. There are some peculiarities that raise some concern in expert community that the council can abuse this. But there are always opportunities for abuse, and we should hope for fairness in the activity of each member of the council in implementing the functions that will be the responsibility of the council. And there is important aspect concerning irrational corporate attitude, and this is in many European countries, not only in Ukraine, and Poland and Hungary also have such problems, and there is some tension between executive and the judiciary power in Poland and also in Hungary, and this balance between independence and responsibility and accountability is really complex, and I only can hope that it if there will be a quality composition of the council where the professionals will be represented with good reputation, ethical people with clear understanding of the tasks and what justice we want to have. Of course, we want to have effective quality justice that would fully protect the rights of people and fundamental values and guaranteed fair justice, fair court hearings. So our time is over, and I would like to ask Roman one question. I want you to answer. Andriy told us that this should be real professionals, and we fully agree that to be on this council, the person should be really professional. So we have critical attitude towards this requirement that a person should be in office for 10 years in order to be the member of the High Council. And tell us, please. At the same time, we see that Supreme Court they accept people from legal community that they can apply and become the judge of the Supreme Court judge. If you can be the judge of the Supreme Council, why there is such a requirement? This 10 years, why they are still requirement? This is a question to Roman. Unfortunately, we are time is pressing, so of course there is mistrust in the situation, and we believe that new forces should be present in the sphere, and people should undergo all verifications and contests to become judges, and this requirement, 10 years in office, taking into account corporate issues, and also we believe that these corporate issues, they are drawbacks, not something positive. That's why we believe that there shouldn't be this requirement, and those people who undergo this contest, and each candidate will be selected and vetted properly. These people, they need life experience, professional experience, and people will have more trust in them than to those people that worked in the system, because 10 years is a long term, and we support the idea that this requirement is ungrounded, and there should be in the council the representatives of the new generation, and it should reflect this idea that Andriy expressed, that there should be representatives of different instances and different with different experience in the court system. So the requirement as to the time in office, it should not exist. So we know that you took part in the meetings of the council, and you can share this experience with us, especially on the transparency of these meetings and the participation of society. I would like to say only one thing, that as of today, we provide all the powers to judges, and we should understand all the risks connected with this. This is good European experience, international experience, but as the experts said, everything depends on the situation in the country, particular situation, and the matter is the reform depends on this changes, and everything depends on the Supreme Council. If they if they understand the situation and the opinion of legal community, and if they consider, discuss this law, and if they adopt this draft law that is awaited by everyone, we believe that this will make positive changes. And if they do not vote for this, there can be some changes as well. So if you have questions, we are ready to answer off records. Thank you, Ukraine Crisis Media Center.